President Trump keeps talking about sending the National Guard to Chicago and to other cities around the country. But remember when he sent those National Guard troops and the Marines to LA a few months ago because of the protests over his immigration crackdown? Yeah, well, today a federal judge ruled that not only Trump, but Defense Secretary Pete Hegseth broke federal law when they did that. In this 52-page ruling issued just this morning, Judge Breyer outlined all the ways that Trump, Hegseth, and the entire Department of Defense violated the Posse Comitatus Act. Now, based on the evidence presented at trial, the judge wrote Trump is trying to claim that he needed the military on the ground to enforce his immigration policy and quell an alleged rebellion in LA. But Judge Breyer wasn't buying it. He wrote, there were indeed protests in Los Angeles and some individuals engaged in violence, yet there was no rebellion, nor was civilian law enforcement unable to respond to the protest and enforce the law. The judge went on to say Trump's true motive is clear, to create a national police force with the president as the chief. And the judge said that's just not how we do it in the United States. Now, we've talked about the Posse Comitatus Act on my page before, but it's worth repeating just in case you missed it. That federal law was passed in 1878, and it is very clear. It says the federal government is prohibited from using military personnel to enforce domestic policies, like police work. The law says the only branch of the military that is allowed to act in any kind of law enforcement capacity is the National Guard, but they can only do that after being invited to do so by the state's governor. Obviously, California Governor Gavin Newsom did not invite the National Guard to California. In fact, he didn't want them there at all, but Trump sent them anyway. Now, here's a juicy tidbit that's buried in Judge Breyer's ruling today. Based on evidence at trial, the judge found that the military members and their leadership all, of course, knew about the Posse Comitatus Act and knew they were not supposed to be performing any kind of law enforcement function on the ground in California. Heck, there was even this handout given to the military trainers who briefed the thousands of guardsmen and 700 active duty Marines that the President and Secretary of Defense called up to California. But according to the evidence, the judge wrote that the military was told the 4 functions listed in red were actually fair game, and the military could engage in security patrols, traffic control, crowd control, and riot control. The judge wrote, this instruction came all the way from the top of the Department of Defense down to Task Force 51. The judge said, these actions demonstrate that defendants, Trump, Hegseth, and the Department of Defense, knew that they were ordering troops to execute domestic law beyond their usual authority. Whether they believe that some constitutional or other exception applied does not matter. Ignorance of the law is no excuse. Now, at this point, the reality is there are only about 300 National Guard troops left on the ground in California. Judge Breyer said those troops can stay. However, they must comply with the Posse Comitatus Act. That means they cannot be involved in any sort of law enforcement activity. This ruling will take effect on September 12th to give Trump and his administration 10 days to appeal. And to be clear, this order only applies to the state of California, though other states' attorneys general will likely be relying on this ruling when they inevitably file their own lawsuits challenging Trump's expected National Guard mobilization in their states. So if you want to read this order for yourself, I'm going to email it out to you tonight in my Facts HQ email, so make sure you sign yourself up.